Since we have already discussed the minute details of Section 439 CrPC, now it's time to discuss some landmark cases, the factors required to be considered by courts while granting bail under Section 439. In a recent case, Harjeet Singh case, the Supreme Court reiterated the principles and important factors to be considered by the court at the time of granting bail. So we are going to see those principles. The first case that we have taken here is State of Maharashtra versus Sitaram Popat with 2004 case. In this case, it was held that at the time of granting bail, the following factors must be taken into consideration. The first is the nature of accusation, means what kind of charge it is. It is a major charge of a heinous offense, an offense involving moral turpitude. It's some serious offense, right? Or whether it is a minor offense. So nature of accusation. The second is the nature of supporting evidence. Now, if it is the initial stage of investigation is yet to be completed. So obviously, all the evidences are yet to be brought on record. But there must be some evidence, some material evidence, some solid piece of evidence that indicates the involvement of the accused. So some supporting evidence. And what kind of supporting evidence is available on record? So the judge has to see this also. What is the nature of accusation? What is the nature of supporting evidence? Third, the severity of punishment. So if the charge is of a very serious kind, then obviously the punishment that may follow will also be very severe. So what is the nature of punishment? That will also be considered, because if the punishment is going to be very serious and very severe, and the accusation is of a very serious kind, supporting evidence is also very strong, then there is a maximum probability that the accused will try to abscond or will try to do mischief with the evidence, will try to tamper with the witnesses, because the punishment is going to be very severe, right? So there is incentive in absconding. There is incentive in running away from the clutches of the law. So severity of punishment has to be seen. Reasonable apprehension of tampering with the witness. So if the prosecution can convince the judge that if the accused is out of the prison, then there is a reasonable apprehension that he will try to tamper with the witnesses. Means he is a muscular person, he is a powerful person, he is influential person, and in the past also he may have done such kinds of things. He may have approached the witnesses. So there is high degree of probability that the witnesses will be tampered with. Then reasonable apprehension of threat to the complainant. If the accused will be a threat to the complainant, then obviously the whole course of prosecution may be ruined. So reasonable apprehension of threat to complainant is also a factor to be considered. Then the next factor to be considered is prima facie satisfaction of the court in support of the charge. Means whether the court is satisfied on the basis of prima facie evidence that the accused may be involved, that the accused may have really committed the offense. Now here, the entire evidence is not on record. And at this stage, the court cannot go into the appreciation of evidence in order to establish the guilt of the accused beyond reasonable doubt. But there must be some prima facie satisfaction that gives court an indication that the accused may have been involved in this. Next, frivolity in prosecution should also be considered. Here, the courts must also see that whether the complainant has made a frivolous complaint, whether the prosecution is frivolous, means it is for some personal vendetta, it is a false charge, that is also a possibility. So the courts have to see that whether the prosecution is frivolous. In the event of there being some doubt as to the genuineness of the prosecution, the accused is entitled to bail. So if the court feels that the prosecution is frivolous, there is a false charge, the prosecution itself is not very serious in conducting the trial, or it's not very serious during investigation has not cooperated with the prosecuting agencies, the investigating agencies. So that shows some lackluster, some lackadaisical approach by the complainant himself, by the prosecution itself, may also give a genuine doubt that it is a frivolous prosecution. In that case, the accused is entitled to bail. Our next case is, so these are the factors to be considered at the time of granting bail under section 439 CRPC. Next case, Ashish Chatterjee versus State of West Bengal. It was 2010 case. Here, some points will be repeated. Whether there is any prima facie or reasonable ground to believe that the accused has committed the offense. So the court will see, are there supporting evidences, some material evidences that have some weight and that indicate, or any person having some ordinary prudence after noticing all these things would really feel, would really have this belief that the accused must have committed the offense. So a reasonable man test will be done here on the basis of the evidences that are on record. The nature and gravity of accusation that we have already seen. What is the nature of accusation? What is the gravity of accusation? What kind of charge is there? It's a charge of some heinous offense, some offense involving moral turpitude. Probability of the accused absconding or fleeing. Now here the prosecution must bring evidences to show that the accused has the propensity to abscond. The accused has the tendency of fleeing, right? It may be based on the past record, or some evidences like the accused already has a passport, or the accused has already made arrangements for the purpose of fleeing, right? The accused has already disposed of his immovable properties, his movable properties. The accused has already diverted funds from his bank accounts. So all these things are indicators that show that the person has made all the arrangements for absconding, all the arrangements for fleeing. Character, behavior. Here, character of the accused is also of prime importance. His behavior at the time of investigation, his behavior during the trial, his behavior in the initial stages. What kind of behavior means whether he was cooperating with the investigating agencies or not, or whether he had the tendency to go away on various flimsy grounds like medical, etc. What is the means that he has? Means if he is a very resourceful person, means he has the means to escape, then obviously there will be a tendency of escape. Whether he has the resources, if yes, whether he enjoys some position in society, some standing in the society. Now, this is a factor favorable for the accused, that he is a person of good position, he is a good person known in the society, he is a renowned person, he is deeply rooted in the society, he has a good standing. In that case, bail may be granted because he is a person rooted to the society. Likelihood of the offense being repeated. If he is an habitual offender, then obviously there is a strong probability that after coming out of jail, after being enlarged on bail, he will do some offenses again, or he will repeat the same offense. So what is the likelihood of the offense being repeated? That will depend upon his past conduct. If he is a habitual offender, if he has been convicted in the past, then there is a strong probability that he would not be abstaining from similar offenses or the same offense. Reasonable apprehension of the witnesses being influenced. So we have already discussed. Here the prosecution has to bring facts before the court to show that once the accused is enlarged on bail, there is a probability that he would contact the witnesses and try to influence them, try to tamper with them. Danger of justice being thwarted, right? If the accused is released on bail, there is a possibility of danger of justice, right? And what role has been attributed to the accused? Whether he is the main accused, whether he is accused because of application of section 34 IPC, means he is not the main accused, he is not the kingpin, but he was just one of them, whether it is because of section 149, that is unlawful assembly, read with the offense. So here we have to see what role has been attributed to the accused. whether he is the main accused or he is just an accomplice, whether he was just present there. So by virtue of section 34 or section 149, he has been brought into all this. So if he has a major role to play, if he is the main conspirator, if he is the kingpin, then obviously bail should not be granted. And if he is not the kingpin, right, if his role is a slight one and he is there only because of section 34 IPC or section 149 IPC, then bail may be granted to him. So we conclude now. Conclusion, it's a very small conclusion here. Grant of bail under section 439 CRPC is a matter involving judicial discretion. So there is no formula actually. There is no hard and fast rule that on what grounds bail must be granted, on what grounds it shouldn't be granted. It is always a matter of judicial discretion. Judge has discretion, wide discretion, but that doesn't mean that he can decide arbitrarily. He has to give reasons. If he is granting bail, he must give reasons. If he is not granting bail, he must give reasons. Valid reasons must be there. If reasons are not there or flimsy reasons have been given, then in that case, it will be considered as an arbitrary order, and arbitrary orders are subject to cancellation. So the appellate court may cancel such an order. So the duty to record reasons is a significant safeguard, which ensures that the discretion is exercised judiciously. There is a need to indicate in the orders the reasons for prima facie concluding why bail was granted, particularly where the accused was charged of having committed a serious offense. So especially in case of serious offense, the judge has a very heavy burden of duty to give reasons, and strong reasons, cogent and coherent reasons as to why he thinks that bail must be granted. So all the above mentioned factors must be considered before granting bail. If these factors are not considered, bail is granted, or if these factors are not considered and the bail is refused, in either of these cases, it's an arbitrary order. It's an arbitrary decision by the judge and therefore must be reviewed. So we have discussed the principles or the factors to be considered at the time of granting bail. So with this, our discussion on section 439 CRPC is over. Next time we will do section 440 and the latter sections.